Good morning, everyone. Welcome to this morning's hearing. I'm going to ask Ms. Wessinger-Hill to read the docket.
Good morning, Mr. Chairman. This is the matter of docket number 2019-386E regarding Dominion Energy South Carolina, Inc.'s proposed code of conduct. The notice of this oral argument was duly noticed for today beginning at 10 a.m. and all matters in the docket are ready, Mr. Chairman.
Thank you. We'll take appearances now.
Good morning, Mr. Chairman and members of the Commission. My name is Chad Burgess, and I'm in-house corporate counsel for Dominion Energy, South Carolina.
Welcome, Mr. Burgess.
Good morning, Mr. Chairman. Jeff Nelson for the Office of Regulatory Staff.
Thank you. Good morning, Mr. Nelson. Okay, nothing preliminarily that we need to do. Someday I'm going to learn how to say preliminarily. But we'll begin, Mr. Burgess.
Thank you, Mr. Chairman. Good morning again. I'm Chad Burgess for Dominion Energy, South Carolina. And this docket is the direct result of the merger proceeding involving Dominion Energy and SCANA Corporation. And in that docket, Dominion Energy clearly understood this Commission's order that Dominion Energy, South Carolina, commit to communicate material information and to be transparent with this Commission. And in this vein of transparency, I'd like to tell you how we got to where we are today. The instructions that this Commission provided to ORS and Dominion Energy in order number 2018-804 were simple and straightforward. More specifically, in your order states that Dominion Energy shall adopt and agree to adhere to a code of conduct developed in collaboration with ORS and approved by the Commission. And such code of conduct shall be developed to ensure that the utility and its officers and employees and agents act to assure that they adhere to their duty to avoid concealment, omission, misrepresentation, or non-disclosure of any material fact or information in any proceeding or filing before this Commission or ORS. That is the framework that this Commission established for Dominion Energy and ORS within which to work. And with those instructions, the company began its work. And as you well know, order number 92-931 is the Commission's order that governs, among other things, affiliate transactions involving Dominion Energy. And this order was put in place in 1992, and it has not been modified or otherwise altered since its issuance nearly 30 years ago. And in creating the code of conduct that Dominion Energy filed with this Commission on July 1, the company began by reviewing that 1992 order. And due to the passage of time, as well as the merger between Dominion Energy and SCANA, it was reasonable and prudent to update the 1992 order. Following the instructions set forth in your 2018-804 order, which I just recited, Dominion Energy updated the 1992 order to reflect the merger with SCANA, and it included 4 new provisions. Those provisions addressed how Dominion Energy would interact with ORS and the Commission, which you required in your order. It also addressed the timing for affiliate transaction reports. It also incorporated specific provisions from order number 2018-804 regarding affiliate transactions. And lastly, it included a waiver provision which simply acknowledged the company's existing rights. These changes were not complex and they were not complicated. And on March the 15th of 2019, Dominion Energy sent its proposed code of conduct to ORS for review and comment. And at the initial meeting between ORS and the company on April 26th, to discuss the code of conduct, ORS informed the company that it had been expecting Dominion Energy to produce a code of conduct similar to that of the code of conduct which had been approved by the North Carolina Utilities Commission as a result of the merger between Dominion Energy and SCANA that was approved in North Carolina. And during that meeting, the company told ORS that the Commission's order did not contemplate such an expectation, that Dominion Energy was unaware of ORS's expectation, and that it would be inappropriate to impose upon Dominion Energy new regulatory conditions by way of a code of conduct that were not considered in the merger docket. On May 7th, ORS sent Dominion Energy redline comments to the proposed code of conduct. Included within its comments were many references to the North Carolina Code of Conduct. And more specifically, ORS informed the company that it suggests adding a non-discrimination clause from the North Carolina Code of Conduct, suggests adding a marketing clause for the North Carolina Code of Conduct, suggests adding the regulatory oversight and complaint procedure clause from the North Carolina Code of Conduct, and suggest adding a section similar to compliance with the Code of Conduct that was from the North Carolina Code of Conduct. And lastly, delete the waiver provision from your proposed Code of Conduct. There was nothing in ORS's comments that explained why the inclusion of these provisions were necessary. And notwithstanding the company's disagreement with ORS on these points, Dominion Energy restyled its Code of Conduct similar to that of the North Carolina Code of Conduct, which included a definition section, a financial and affiliate transaction section, and a filing requirement section. The company also reorganized its Code of Conduct in such a manner so that everything could be easily located in the document. Additionally, the company accepted nearly all of ORS's red line edits except for those additional clauses that ORS sought to include for the North Carolina Code of Conduct. And in rejecting the North Carolina clauses, Dominion Energy informed ORS that these matters were not necessary and that these issues were not issues in the merger docket. And all of this was done by email on June 4th. On June 17th, ORS sent Dominion Energy additional red line edits, and it repeated its suggestion that Dominion Energy include specific sections from the North Carolina Code of Conduct. Again, these clauses address non-discrimination, marketing, regulatory oversight, a compliance officer, independence and information sharing, and a complaint procedure. And ORS also provided no basis for including these provisions. By email dated June 20th, Dominion Energy responded and again accepted nearly all the red line edits that ORS had proposed. However, the company rejected the additional provisions from the North Carolina Code of Conduct and again told ORS that expansion of the Code of Conduct was unnecessary and that these matters were not raised in the merger docket. On June 25th, Dominion Energy and ORS participated in a conference call to discuss the Code of Conduct. ORS presented additional comments, which the company accepted. As for the North Carolina Code of Conduct provisions, Dominion Energy repeated its prior arguments against inclusion of those provisions. Dominion Energy told ORS that it would file a Code of Conduct on July 1 and asked ORS to support the filing. ORS informed the company that it would file a letter in response and let the commission know that it believed that the North Carolina provisions should be included in the South Carolina Code of Conduct. The next day, Dominion Energy emailed ORS the version of the Code of Conduct that the company ultimately filed with this commission on July 1, 2019. Mr. Chairman, those are the events that led up to the filing of the Code of Conduct. And I don't know if the commission has ever reviewed the North Carolina Code of Conduct, but it is complex and complicated. And for reasons that exist in North Carolina, it has evolved into what it is today. And as I stated earlier, Dominion Energy's initial draft of the Code of Conduct was designed to be simple and understandable and take matters that have worked in South Carolina for nearly 30 years and bring those matters forward today. And at ORS's request, Dominion Energy evaluated the North Carolina Code of Conduct and accepted those aspects that were meaningful for South Carolina. But some things in the North Carolina Code of Conduct did not make sense for South Carolina, and there was no practical reason for including these provisions in the South Carolina Code of Conduct. Dominion Energy, and I want to be clear on this point, does not have any issue living with rules that are designed to protect customers. In my time with the company, I cannot think of one instance in which Dominion Energy has run into trouble with the mandates of the 1992 order. The company understands the 1992 order and has been applying that order to its operations for nearly 30 years. The same people living under that order before the merger are the same people at the company today. Nothing has changed in that respect. But now, ORS wants to add new provisions because from what the company can tell, opportunity has presented itself. If these provisions are accepted, then the company will have to live with them on a day-to-day basis. And while they may look good on paper, I can tell you from firsthand experience, it will be difficult to apply these provisions to real-world issues, and there will be a cost of compliance. And the company is not convinced that these provisions are added for the benefit of customers. It's more likely that the company will find itself in a game of gotcha with ORS if these provisions are implemented. Rather than adopting ORS's recommendations, it is better for these issues to grow organically. If ORS identifies an issue or problem, then please tell the company. Dominion Energy will be more than happy to address it, and if it requires fixing, then the company will fix it. But ORS has not identified any specific issue that it's trying to correct with its suggestions to the Code of Conduct. From the company's perspective, ORS merely looked across the border in North Carolina and concluded that these provisions exist because these provisions exist in North Carolina, they likewise should exist in South Carolina. So now let's look at ORS's specific recommendations. They want to add a non-discrimination clause, a marketing clause, a compliance officer clause, a customer information clause, a complaint procedure clause, and a periodic review clause. And they also want to eliminate the waiver clause that the company's proposing. All of these provisions that ORS seeks to add are taken directly from the North Carolina Code of Conduct. And again, ORS is attempting to make what should be a simple matter into a complex one. ORS has not provided the Commission with any analysis whatsoever of the recommendations. It simply provides you with a conclusory statement that these provisions will benefit customers. It doesn't tell you how customers will benefit. It doesn't quantify these purported benefits. And more importantly, it does not provide you with one example, actual or anticipated, of where Dominion Energy has engaged in activity that warrants the imposition of these requirements. For example, ORS wants to include a provision that Dominion Energies will not discriminate against non-affiliated entities. In all my years with the company, I am unaware of any instance of discrimination by Dominion Energy employees, and if ORS is aware of such an instance, then I would encourage them to inform me, and I'll report back to leadership, and I'm confident that they will put a stop to such activity. Likewise, ORS seeks to include a provision aimed at protecting shippers of natural gas who use Dominion Energy's natural gas system. ORS also wants Dominion Energy to advertise on behalf of natural gas marketers by requiring the company to post on its website a list of contact persons and telephone numbers for all gas marketers that are active on the company's natural gas system. This provision may work in North Carolina because they are clearly suited to fit the natural gas regulatory environment in North Carolina. South Carolina's natural gas regulatory environment, however, is different. In addition to this difference, the company is unaware of any reason to impose these requirements upon Dominion Energy. And if ORS is aware, then the company would respectfully request that ORS bring these matters to the company's attention. And if they're not willing to do so, then they should bring them to your attention. ORS has also included a tying provision that prohibits Dominion Energy from requiring customers who sign up for electric or natural gas service to also use the services of another Dominion Energy company. The company questions why this provision is included because when a person takes electric or natural gas service from the company, Dominion Energy does not require that person to also take service from another Dominion Energy company. So I ask, what is ORS trying to solve by including such a provision? And here's another, and I quote, "Electric generation shall not receive priority of use from Dominion Energy South Carolina that would supersede or diminish Dominion Energy South Carolina's provision of service to its human needs, firm, residential, or commercial customers." I'm not even sure what that language means, which goes back to my argument earlier. If you adopted this provision, then here's what will happen in the real world. My phone will ring, and someone will ask me, what is this provision? What does it mean? And how do we apply it? And my answer is going to be just what I gave you. I don't know what that means. While this may look good on paper, in the real world, it will be difficult to manage and implement. ORS also singles out marketing in its recommendations. I'm not aware of Dominion Energy South Carolina engaging in joint marketing with an affiliate company. And if any has occurred, I'm certainly not aware of any problem that is created. If any exists, ORS hasn't made the company aware of it, and if a problem did exist, then the company would address it appropriately. ORS is also recommending that Dominion Energy South Carolina designate a chief compliance officer who has responsibility for the merger conditions in the Code of Conduct. So you're probably asking yourself, what's wrong with that? And it's not that there's anything wrong with that, but it doesn't accurately describe the importance that Dominion Energy places on compliance. Compliance at Dominion Energy is not a one-person job. It is a shared responsibility of the company, and Dominion Energy expects every single employee to understand and comply with this commission's merger conditions and Code of Conduct. This is evidenced by the language in Section 3.E.4 of the Code of Conduct, which states that Dominion Energy will provide proof to the Commission and ORS that it has trained its employees annually on the Code of Conduct. Moreover, in Section 3.E.3 of the Code of Conduct, it states that the company's officers, employees, and local management will be accessible to this commission. There is no need to single out one person when you already have language in the Code of Conduct that requires every single officer and employee to be available to you, coupled with Dominion Energy's commitment to train every employee on the Code of Conduct, as well as the company's expectation of all its employees to understand and comply with the Code of Conduct. ORS also wants to include a provision that addresses the sharing of customer information. And I'll pause here because ORS may argue to you later this morning that had you accepted this provision, then the HomeServe matter would have never come before you. And that is incorrect. There's nothing in ORS's recommendations that prohibit Dominion Energy from allowing a non-affiliated company to use Dominion Energy's mark on its communications. Plus, there are other means by which HomeServe could have procured the names and address of the company's customers, and those customers still would have received the same communication that they received in late 2019. But I understand this docket is not about HomeServe, and there's another docket to address that, but I only bring this up to demonstrate that ORS's recommendations would not have prevented that issue. Let's look at the complaint procedure recommended by ORS. Again, another provision that is not necessary. To begin with, commission procedures for complaints are governed by your regulations. And ORS's action in this docket is nothing more than an attempt to sidestep the rulemaking process. If ORS wants to implement changes such as the one that is proposing to the complaint procedures, it must initiate a rulemaking proceeding before you. But more importantly, ORS appears to be attempting to fix a problem that doesn't exist. The company is unaware of any issue that ORS has had with Dominion Energy when responding to a complaint. The company replies to requests for information from ORS and works with ORS on these issues. And this is evidenced by the fact that so few complaints are filed with this commission against the company. Additionally, this clause appears to be directed at complaints that may arise in connection with Dominion Energy's affiliates. And I've never been aware of a complaint made against Dominion Energy South Carolina concerning the matter in which it does business with an affiliate. Again, the commission should allow this to grow organically, and if a problem exists, then let's address it then. ORS also wants a periodic review. I first want to address a statement that ORS made in its November 5th letter in which it stated that it reached an agreement with the company on a 4-year review period. This is incorrect. The company never agreed with ORS on a 4-year review period. This matter arose out of a conversation with Dominion Energy's business personnel and ORS's business personnel without the presence of lawyers. And Dominion Energy did not interpret this conversation to include a settlement of any issue or an agreement upon a periodic review. And had such an agreement been reached, Dominion Energy would have included language in the Code of Conduct that it presented to you on July 1. And moreover, ORS never once raised this issue when the parties were exchanging drafts, and never once indicated that we had an agreement and indicated to me that we've left that out. Dominion understands that it is within this commission's discretion to demand that the company appear before it, but simply to schedule a periodic review for the sake of scheduling a periodic review without any basis for doing so is a waste of judicial resources as well as time, energy, and money. There's nothing that prevents ORS, or anyone else for that matter, from initiating a proceeding before this commission. To do so, they must simply follow your rules and regulations and provide a basis for the relief they seek. Rather than schedule a review for the sake of scheduling a review, the better course of action would be for a party to initiate such a proceeding when it believed a proceeding was appropriate, and the commission can then decide at that time whether or not such action should proceed. Furthermore, as I mentioned earlier, because this is set up as a game of gotcha, if ORS finds that the company has violated the Code of Conduct, then I'm confident that ORS will immediately initiate a proceeding before this commission well in advance of any periodic review. And lastly, the waiver clause. ORS argues that by including a waiver clause in the Code of Conduct, that the company has diminished its commitment to being transparent by stating in written form its existing rights. This argument defies logic, and quite frankly, the company does not understand how transparency is defeated by stating the company's rights in a written form in a public document. Dominion Energy could understand such an argument if the company did not include this provision, but to include it and then have ORS claim that the company is not being transparent is remarkable. Moreover, ORS's argument ignores Commission Order 2018-804, which plainly states in written form that the company's rights with respect to privileged and confidential information. And in conclusion, Dominion Energy has behaved responsibly and has done nothing to deserve the imposition of these requirements. Moreover, ORS's recommendations have exceeded the scope of your requirements set forth in Commission Order 2018-804. They also have the effect of unnecessarily adding complexity to the code of conduct and making compliance with the code of conduct more difficult by applying these theoretical concepts in the real world, all of which lead to increased costs, which are ultimately borne by the company's customers. And again, I point out that ORS has not informed this commission of the cost of compliance if it were to accept ORS's recommendations. And let's contrast that with promulgating a new regulation. Because in that instance, the commission is required to identify costs associated with a proposed regulation. So while these regulations may look good on paper, we don't know how much money they will cost to implement, but we know from experience, if you accept ORS's recommendations, that the company will be required to live with these conditions until the end of time, and that expense will never go away. At the end of the day, ORS's argument of one size fits all is conclusory and should be rejected by this commission. North Carolina is not South Carolina, and likewise, South Carolina is not North Carolina. They are separate and sovereign states that operate under different laws and in different regulatory environments. Contrary to ORS's belief, what may be good for North Carolina does not automatically translate into good for South Carolina, which is why the better course of action is to allow these matters to grow organically and allow the company to address them if they arise. Therefore, Mr. Chairman and members of the commission, the company respectfully requests that the commission reject ORS's recommendations and approve the code of conduct as filed by the company on July 1. Thank you.
Thank you, Mr. Burgess. Let's go, Mr. Nelson.
Thank you, Mr. Chairman, Commissioners. This really is, and Mr. Burgess has, pointed out that our position is largely based on the North Carolina Code of Conduct. I think that the question for this commission really is fairly simple, and is that should this commission allow Dominion to provide a lower standard of conduct for its South Carolina customers than it provides for its North Carolina customers? The issue is what protection should South Carolina ratepayers be given under DES Code of Conduct, and whether or not that was specifically addressed in the merger docket is really irrelevant, because this is an opportunity for this commission to, in fact, provide a better standard of conduct for the company to its South Carolina customers. They already have these standards in place in North Carolina. They know what these standards are. Dominion operates under them in North Carolina. I don't understand why it's so difficult for them to just apply the same standards, the same rules down here. In fact, it seems like it would be more difficult to, in fact, have a different code of conduct and a different standard in South Carolina as opposed to what they currently have in North Carolina. ORS and the company did, in fact, as Mr. Burgess has stated, we had a number of conversations to discuss updating and revising the current code of conduct that SC&G has been operating under. As a result of that collaboration, DES did file with this commission its proposed code of conduct, and a month later, ORS filed its letter describing 7 additional components, which Mr. Burgess has outlined for you. Today, I'd like to discuss in a little bit more detail than what was provided to y'all previously, those seven recommendations that ORS has made. And in particular, when I reference a letter or ORS's prior position, that's going to be referring to our November 5th of 2019 letter that was filed with the commission. To provide an overview of the 7 recommendations, 5 are additional sections that would offer consumer protections not currently covered by the company's proposed code. Each of these 5 sections are currently part of the Code of Conduct under which Dominion Energy North Carolina and PSNC operate in the state of North Carolina. And they include a non-discrimination clause, marketing clause, installment of a compliance officer, customer information clause, and a clause covering the complaint procedures. In addition, ORS expressed concern in the way in which the company presents its waiver clause in its proposed code. And finally, ORS proposed establishing a review period, which it recommended to this commission in its letters of both August 2nd and November 5th of last year. I'd like to discuss in a little more detail in particular now these 5 additional customer protections that we've recommended. The non-discrimination clause. This clause is proposed by ORS, again, mirrors the one which has currently been approved by the North Carolina Utility Commission for both Dominion Energy North Carolina and PSNC. The contents of this provision in its entirety can be found in ORS's letter of November 5th, beginning on page 3 and ending on page 5. In essence, the non-discrimination clause is intended to reduce the possibility that affiliates may benefit from preferences not afforded to non-affiliates. This provides additional protections to consumers through giving preference to affiliates over non-affiliates, applies tariffs equally to Dominion Energy affiliates and non-regulated utility operators, and provides consistency in the response and approach to requests for service, and it assures impartiality in business dealings. All of these are just reasonable requirements on a company that should operate, that should be included in the Code of Conduct. ORS believes the company's position is counter to the position this commission has set forth in Order Number 2018-804, which was issued in Docket 2017-370E. Going to the marketing clause. The marketing clause recommendation by ORS is similar to the provisions approved, again, by the North Carolina Utility Commission for the benefit of North Carolina customers, and can be referenced in the November letter beginning on page 5 and ending on page 6. As proposed, this clause would better define how marketing materials operating from affiliates and non-regulated utility operators can and cannot represent a relationship with Dominion Energy. For example, the clause describes the type of disclaimers that must be used on such marketing materials. This clause would also help ensure transparency for any marketing materials or similar communications circulated by Dominion Energy South Carolina affiliates. We believe that the only viable alternative to what we have proposed here would be a strict prohibition, which would include third parties such as HomeServe. And again, as Mr. Burgess mentioned, we're not here to argue that case, but it does relate to this clause that we've inserted here. We believe that ORS's position is a reasonable compromise from what the company has proposed and from a strict prohibition. The compliance officer, the North Carolina Code, North Carolina for Dominion Energy North Carolina and PSNC provides for a compliance officer to oversee compliance with the code. ORS recommended a similar provision of the Code of Conduct for Dominion Energy South Carolina so that South Carolina customers can also realize the benefit of having an individual to monitor adherence to and compliance with the Code of Conduct. This provision can be referenced in the provided letter, again, the November letter on page 7. The presence of a compliance officer would provide valuable benefits to desk customers and would ensure additional transparency in complying with the merger conditions. And it is possible that costs could be mitigated by sharing resources between the North Carolina compliance officer and South Carolina. Theoretically, we can have one compliance officer, or at least certain information could be used by both of them to reduce the cost of this. As an alternative, it is possible the Regulatory Compliance and Privacy Program Manager, which is described in SC&G's Customer Information Privacy Policy, and that's on page 51 of the Affiliate Transaction Report, filed with this commission on June 28th in docket number 89-230-EG. It could assist in, if not fulfill, the duties of the proposed compliance officer. So you could possibly take the Regulatory Compliance and Privacy Program Manager and just layer this compliance officer duties on that person. In the reference privacy policy, the Regulatory Compliance and Privacy Manager will, quote, coordinate the development, implementation, modification, and communication of this policy. Customer information. The Customer Information Clause proposed by ORS would provide South Carolina customers with additional protections in how their information may and may not be shared with affiliates and non-affiliate third parties. This provision is discussed in the ORS letter of November 5th, beginning on page 7 and ending on page 9. In the proposed code filed by Dominion, the customer information section is brief and requires that Dominion Energy South Carolina have written consent from a customer before that customer's information can be disclosed to any affiliate. The section proposed by ORS and approved by the North Carolina Utility Commission expands on protections surrounding customer information to require customers' consent to disclose information to any affiliate or non-affiliated third parties, again, such as HomeServe. In tandem with the proposed marketing clause, this provision would further protect customers in instances such as the recent concerns related to HomeServe that were brought to this commission. Believe this additional language also provides the customer information clause to be posted on the Dominion Energy South Carolina website so that it would be readily available to customers. A complaint procedure. The clause proposed by ORS would detail how the company will resolve complaints in its relationship with other affiliates and non-regulated utility operations. This provision is referenced in the November 5th letter beginning on page 9 and ending on page 10. ORS has recommended that this provision be included so as to introduce additional transparency in the resolution of customer concerns. ORS also notes that as with the code approved by the North Carolina Utility Commission, this provision would not alter a customer's right to also file a complaint with the Public Service Commission. Those are my 5 additional clauses that we had recommended. One thing that we have recommended is that, or one concern that we have regards the waiver clause that has been proposed by Dominion to be included in the Code of Conduct. This is referenced in the November 5th, 2019 letter on pages 10 and 11. ORS has concerns with the emphasized text, specifically without waiving its rights to self-advocacy and supporting positions in the regulatory proceedings before the Commission, and specifically reserving all of its rights under the law. ORS maintains there is no need to include such language in the DES Code of Conduct. By including this language, ORS believes that the company is diminishing the appearance of its commitment to transparency. Additionally, the company can, of course, make whatever legal or factual arguments that it wants in any proceedings before this Commission, and cannot waive its right to do so by issuing the Code of Conduct. This is unnecessary, difficult language. Mr. Burgess had talked about some language being undecipherable. If you look at this is something that a lawyer maybe could decipher, but generally, if this is something that's put out there for the general public, it'd be very difficult for the average customer to figure out what is being said here. A periodic review that we have proposed. We have proposed a review every 4 years in the August 2nd letter, the first letter that we had filed with this Commission, so that the Code of Conduct for Dominion Energy can be occasionally reviewed for accuracy and to ensure that the merger conditions intended by this Commission are being met. This recommendation can be referenced in the November 5th letter on page 11. The periodic review would also serve to update thresholds that were reviewed and adjusted from the prior Code of Conduct for SC&G. Taking the time to review this document at regular intervals would benefit customers by ensuring that the best interests of the customers are being met by a current Code of Conduct from the company. In conclusion, ORS maintains its commitment to representing the public interest in utility regulation. As part of this commitment, ORS presents these recommendations as valid, valuable, and crucial customer protections to accompany the Dominion Energy South Carolina Code of Conduct. South Carolina consumers should benefit from the same, if not better, consumer protections than those afforded to customers in other states. That the 5 additional sections of ORS recommendations be included in the DES Code have been approved by the North Carolina Commission for the code governing Dominion Energy North Carolina and PSNC that lends credence to the validity of providing these same protections to South Carolina customers. I don't believe that this would be difficult, again, for the company to manage. They already have these standards and manage under these standards in the state of North Carolina. This would be applying the same standards into South Carolina as they currently provide there. Why allow, and Mr. Burgess made several points about ORS being able to come to this commission or consumers being able to come to this commission. Why have that as the resolution? Why not put these stops in place? Why not put these standards in place so that we don't have to hit that position where a consumer feels like he has to come to ORS or come to the commission if he is being protected by a sufficient Code of Conduct? Again, the same is being provided to his neighbors in North Carolina. We believe that that is a reasonable standard. Thank you.
Thank you, Mr. Nelson. Thank you both. Commissioners, are there questions of either of these gentlemen? Commissioner Howard.
Mr. Burgess, I am not an attorney, but the clause that you had a problem with understanding, will you repeat that again?
Electric generation shall not receive priority of use from Dominion Energy South Carolina that would supersede or diminish Dominion Energy South Carolina's provision of service to its human needs, firm, residential, or commercial customers.
Mr. Nelson, will you give me your interpretation of that clause? Pardon? Well, I thought you had it memorized.
Excuse me. Basically, I believe that this is saying electric generation can't be receiver priority of use from desk. In other words, electric over gas. If you're a customer that's receiving both of these, that the company cannot require a priority of use of their electric service, which would supersede or diminish desk provision of service to the human needs, firm, residential, and commercial customer. And human needs, maybe you can take out, say service to residential and commercial customers. So basically, both residential and commercial customers would be protected to ensure that the company isn't attempting to prioritize, for some reason, its electric over its gas services.
Commissioner Howard, I would add what that basically is saying, that it's actually okay to discriminate against electric customers in favor of natural gas customers. And I can certainly understand why North Carolina would have that provision, because the company operates Dominion Energy North Carolina Electric. It also operates Dominion Energy North Carolina Gas. They're two separate business operations, two separate legal entities in North Carolina that provide two different services, two different companies. We don't have that issue here in South Carolina. Dominion Energy South Carolina is a combination utility which provides both electric and natural gas. And as this commission is well aware, gas is dealt with in a PGA proceeding, and we had that proceeding just last fall, where this commission and ORS indicated that there were sufficient gas supplies to provide our customers during the winter heating season. And as evidenced by the warm winter that we've had this year, there are sufficient gas supplies so that you don't have that issue. And secondly, electric generation plans completely different from the LDC. Electric generation is handled through the fuel proceeding, which is ongoing right now. So the problem, and I'll put that in quotes, that ORS has identified doesn't exist here in South Carolina because of the regulatory environment in which this commission and Dominion Energy South Carolina operate. So that clause is wholly unnecessary here in South Carolina. I can certainly understand why they would have that clause instituted in South Carolina, or excuse me, in North Carolina, but for here, it is just nonsensical.
Mr. Nelson, have you had any conversation? I don't know that you're allowed to do it. I'm not familiar with the code as far as ex parte communication. But are you allowed to communicate with the consumer advocate, since you're both represents the consumer?
Yes, sir. Yes, we are.
You discuss this with the consumer advocates and what their opinion?
I have not had a discussion with the consumer advocate on this. To be honest with you, Commissioner, I think they're very busy right now just trying to get their feet on the ground and participate in the two water and sewer rate cases that are coming before this commission. As far as I know, we haven't had any discussions with them on this specific topic.
Did you discuss code of conduct with any other state? And the one that comes to my mind is Virginia. Do you discuss their code of conduct difference or how they were treated? Because Dominion obviously is in Virginia, so.
Yes, sir. I can't guarantee that we've talked to any other states. I just don't know for certain. I know that we have looked at other states' code of conduct, and we used several of those. And obviously what we focused on out of all of those that we looked at was the state of North Carolina, because Dominion Energy operates there and because it's our neighbor.
Does restructuring come into this conversation at all? Either one of you?
When you say restructuring, you talking about?
Yeah, there's some restructuring elements in both states, I believe North Carolina and Virginia, if I'm not mistaken. I mean, they're on the PJM, one of them, I think, in North Carolina and Virginia.
I'm not, Mr. Commissioner, I'm not familiar with any restructuring efforts that may be going on in North Carolina with respect to PGM.
I'm not talking about efforts so much as the implication in the code of conduct, whether it's restructured or not.
No, sir, I did not, and the company did not have any discussion with the ORS about restructuring.
No.
I would agree with that.
I thank both of you.
Commissioner Hamilton.
Howard covered my question.
Okay, thank you. You got anything else, Commissioner?
I'm going to turn my mic off right now.
Thank you. Commissioner Whitfield.
Thank you, Mr. Chairman. Got a question for each of you. Mr. Burgess, I guess first, I know we're not here to discuss home serve, as both of you have said, but you certainly can understand the concern from the public and from customers of Dominion about the disclosure of customer information without the customer's consent. And you can certainly understand that. And again, I know we're not here to address HomeServe, but if you could touch on that again, that obviously is a area that's of significant concern to different classes of customers, of ratepayers, and certainly an area of concern for this commission and obviously ORS too. So could you touch on that just a minute?
Sure. So as I understand it, ORS will have their report prepared for you in March, just next month, and I presume they'll lay out their findings and any recommendations they may have with respect to that matter. But from Dominion Energy South Carolina's perspective, the information that was shared with HomeServe consisted of customers' names and addresses as well as account numbers. And the reason the account numbers are shared, and the account numbers are Dominion Energy's property. The company is the one who generates those numbers for identifying marks on those customers' bills, is because the HomeServe charge is placed on a customer's bill if they sign up for that service. So the only point that I was making there, Mr. Whitfield, is that regardless of whether or not you had already adopted ORS's recommendations, the company still, under its agreement with HomeServe, would still have been allowed to engage in HomeServe using the company's mark to solicit its services to the customers of Dominion Energy.
I know there still appears to be a lot of concern in that area, and I'm sure we'll be addressing that as ORS brings their report forward. But I'm going to move on to a question for you, Mr. Nelson, and kind of back to what Mr. Burgess was saying. Mr. Nelson, I would say he described the question that Commissioner Howard asked him about the differences in our state, and given the fact that part of Dominion Energy's business in North Carolina is unregulated by this commission, and they've got some areas of Dominion Energy that are incorporated separately in North Carolina that provide electric service, and of course, as he stated, they're a combined utility here in this state. Would you not agree that certainly the regulated gas operations here or regulated combined utilities here are certainly a different scenario than what you have in North Carolina? And for instance, the natural gas part of their combined business here is heavily regulated, and they have to come in here annually multiple times, and of which ORS is a party of record in all those proceedings. So with him explaining it that way, would you not agree with him that there are big differences and that it might be, I want to use the word unnecessary, that's not the word I'm looking for, but perhaps duplicative, maybe, since we already have regulatory authority over the businesses the part that's in this state?
If the concern's that one sentence, I don't think it's that important. I mean, if the commission chooses to strike that one sentence that Mr. Burgess has put out of all of these recommendations that we've made, I think I could live with that.
Okay.
I'd be fine with that. Now, I do think.
Oh, we got a partial meeting of the minds here. Okay.
But I do think that it is important to provide as many protections to South Carolina customers as possible with this opportunity that's presenting itself to the commission right now. Don't let the opportunity escape to make sure that our customers receive equal protection. There may be a couple instances where there's a little something different as far as the services that are provided in the state of North Carolina. But generally what we have asked for here are general customer protections to be provided in the Code of Conduct.
Well, I certainly appreciate that, Mr. Nelson, and certainly, we obviously, you and Mr. Burgess, we all recognize we're two different states and two different business models and two different regulatory regimes, for lack of a better word. So thank you for that answer, and that's all I have, Mr. Chairman.
Thank you. Any other questions, commissioners? Okay. Do either of you want to have any other statement to make? Replying to each other, you've replied a lot to each other already, but I want to give you that one last opportunity.
Mr. Chairman, very briefly, just I want to point out, Mr. Nelson, on behalf of ours, made the argument that Dominion Energy already knows the code in North Carolina, and that's not accurate, and that's because that code applies to PSC. PSC has its own set of employees who do business for PSC. Dominion Energy South Carolina has its own employees who do business for Dominion Energy South Carolina. So the Dominion Energy South Carolina employees, they would have to go learn that code. Secondly, and the company totally gets the argument about why not customers should have the same protections that North Carolina has. The difference is, again, the jurisdictions are different. The code was established with North Carolina in mind, not here, and we just don't grab things from North Carolina and apply them down here in South Carolina, and I know this commission doesn't do that. And the standard that this commission has to apply, it's not why not, or what's the harm, or should customers have the same protections. The standard is what's just and reasonable, and what's reasonable and prudent. And what's reasonable and prudent is to analyze the recommendations, understanding that there is a cost that comes with compliance. And I don't think it's appropriate for the commission to blindly accept recommendations when ORS has not presented you with one example of where these purported protections would have helped on some matter in the past. And they likewise have not provided this commission with a price tag on how much these protections would cost customers. With that, thank you, Mr. Chairman.
Thank you. Mr. Nelson.
Very briefly, Mr. Chairman. The Code of Conduct, this whole proceeding has come out of the abandonment and merger docket. And as y'all remember, the reason that we wanted this company to establish a good code of conduct is because of issues that were raised in that abandonment and merger docket. This is the opportunity now that's presented for the commission to establish that code of conduct and make the company live by it. Thank you.
Thank you. All right. Appreciate everybody being here. There's nothing else from the commissioners. We're adjourned.